What's up everyone, it's the Law School Lumberjack here again with another video as part of our Contracts Law 101 series. So I got to thinking, a lot of you guys who are probably watching this channel right now are probably either entering law school or if you're watching in September are just starting law school. So I thought, why don't I go back to the basics and start discussing some of the foundational lessons on contracts. And the first one I'm going to talk about is what are the 6 elements of a contract. So very basic. And so this video is just going to give a brief primer on the 6 elements of the contract. Your professors might go into more detail, but I thought just for those who are either starting law school or trying to get ahead, it might make sense to just provide a primer on each. So let's begin. Some people say there's 6 elements, some people say there's 7. For the sake of this video, we'll say there's 6. The 6 elements are offer, acceptance, consensus ad idem, consideration, legality, and capacity. So I'm going to use an overarching example in this video being someone trying to sell their car on an online platform to potential buyers, essentially. So let's start off with the first idea. It is an offer. So you've listed your car. The first thing that happens to start off the contract, one, you need basically an intention to contract, and that's kind of shown through an offer. So a potential buyer contacts you and says, you know, how about I purchase your car for $5,000? Now you have a choice there. You can either move to acceptance or you can make what's called a counteroffer. So what a counteroffer is essentially you reject the initial offer and make an offer under new terms. Now it's important to remember that once you make a counteroffer, technically that original offer is off the table. So for example, let's say you offered $7,500 for your vehicle. The potential buyer says, no, I'm not interested. And you said, okay, I'll accept the $5,000. That potential buyer has the ability to either reaffirm that offer or walk away and say, nope, that offer is off the table. I'm not interested in contracting with you anymore. So moving on to the second element of a contract, there is acceptance. So there's 2 things to remember about acceptance that are of note. So the first thing to remember is at any point the offeror, or in this case the buyer, can revoke their offer, basically take their offer away by giving you notice before you accept. So sometimes with an acceptance, you're racing against the clock to accept before the potential buyer can pull their offer off the table. So let's say, for example, the buyer really valued your car and offered you $50,000 rather than $5,000. You'd obviously want to accept pretty quickly in order to ensure that that buyer could not revoke the offer, assuming that that offer was intended to be $50,000, of course. The second important thing about acceptance that you might learn in law school is something called the mailbox rule. And essentially how the mailbox rule works is when you're racing against the clock, way back when people used to send things by mail, all you would have to do was put your acceptance in the mailbox in order to prove that you accepted the offer. You didn't have to prove that the actual acceptance was delivered to the offeror. So that's essentially acceptance. Basically, the formation of the contract obviously requires 1, someone to make an offer, 2, you have to accept it. Now moving on to number 3, we have consensus ad idem, which is also known as a meeting of the minds. So basically what consensus ad idem, in brief, and again this is just meant to be a primer, the buyer and the seller agree basically what's being sold and kind of the terms of the contract. So if the buyer says, I will buy this car, being let's say it was your Toyota, they say, I will buy your Toyota for $5,000, you say, yep, that's good. It's clear that there is consensus ad idem because it's clear that you guys both intended to contract and the terms you both agreed on. Now, let's give an example where consensus ad idem might be in question. So let's say that instead the buyer said, I will buy your car for $5,000. And you assume that he meant your old Neon, whereas in fact he meant your Toyota Corolla. So obviously it's not clear what the terms are, and I think in that circumstance it would be fairly clear that there was not consensus ad idem. Number 4 is consideration. So in order for a contract to be enforceable, there must be value going both ways, both from the buyer to the seller and from the seller to the buyer. So what that means is, clearly in this example, $5,000 for a vehicle, there's value going both ways. There's value coming in the form of money, and in exchange, the seller is giving the buyer a vehicle. And there's clearly things that do not form a contract, and that's as a result of a lack of consideration. So for example, gifts, whether they be inter vivos, which means being given during one's lifetime, or testamentary gifts, which are basically gifts which happen when someone dies through a will. Both of those do not lead to a contract, and as a result, you usually will not deal with those in contract law. You deal with them instead in property law, so if you want to check out some of my property law videos, feel free to check out my channel, but that is basically gifts like that are not dealt with in contract law. So there's also something called past consideration, and that's set out a bit more in my video called Folks and Beer, which I'll link down below. Essentially, past consideration, which is a previous obligation, will generally not count as consideration to form a contract. Let's move on to our final two elements of a contract. Number 5 is capacity. So in order to make a contract, you have to both have the mental capacity to make a contract, and as well, generally, you have to be of a certain age to have the capacity to contract. Now, as a general rule, if something is for life-sustaining goods or necessities, you don't have to be over 18 or over the age of majority in order for the contract to be held enforceable. So for example, if you are purchasing food or maybe purchasing necessary clothing, for example, if you're under 18 or a minor, you are still, you can still be bound to the contract to purchase those necessities. But as a general rule, if you are under 18 and are buying non-necessities, then the enforceability of the contract gets called into question. And number 6, we have legality. Obviously, the courts aren't going to uphold illegal contracts. So if someone wants to purchase something illicit for money, even though there's consideration, the courts will not enforce that. Another thing is that certain items, even if they might not be technically illegal, or certain contracts that may not be technically illegal, the courts might hold them void on public policy grounds. So as a result, the contract has to be for basically legal items, and the contract cannot offend public policy. So for example, a vehicle, $5,000 being traded for a vehicle, that's clearly within the realm of legality, and as a result, that would be an enforceable contract. I hope this video was helpful. Again, it was just meant to be a primer for everyone who is either entering or starting law school. In my other videos, I go into quite a bit more detail about contract law, property law, and law school in general. If this video was helpful, please feel free to like and subscribe. Take care. Have a wonderful day. Thank you.